And thank you to everyone joining us this afternoon. Good afternoon and welcome. This is an interesting topic because enforcement does tend to get your blood flowing a little bit, but it is one of the more important areas that affects community association management and community association living. Having done this for 37 years now, I have found consistently that the level of energy I experience from associations is different when they're drafting restrictions than it is when we're talking about what steps to take to enforce. For some reason, the adrenaline flows when you're drafting restrictions and we want to regulate this and we want to regulate that. But when it's time to enforce, people tend to get more conservative. I appreciate that, but part of the discussion today is to take you through the process from inception. And inception is not when the violation occurs. Inception is when you conceive of the restriction and then you draft a restriction to accomplish your goals in terms of identifying what you want to restrict and putting it in plain English. So with that, let me welcome my two partners, Howard Pearl from our Fort Lauderdale office and Liliana Farinas-Sabogal from our Coral Gables office, both of whom have been colleagues of mine for, well, more years than we'd probably care to acknowledge. These are both highly experienced community association lawyers, both of whom have a lot of experience with enforcement. So Lily, allow me to start with you. When a client comes to you and says, we want to restrict X, what advice do you give them in terms of drafting and adopting? And let's start with, can you explain to the people in attendance what the difference is between adding something to the rules as opposed to adding something to the declaration? Unmute.
Oh, the curse of Zoom and muting and unmuting. My apologies. Good morning to everybody. Sure, there's a big difference. Obviously, the declaration almost always is going to require a unit owner vote or a member vote in order to amend it. And most communities have the right of the board of directors to enact rules and regulations without that vote. So if the community is looking to implement a new restriction that's not already in their documents, then a lot of whether they put it into their declaration or their rules and regulations is going to depend on what the requirements in those documents are already. So if you are talking about, let's say, restricting a pet, and your declaration currently has a pet provision in it allowing each unit owner a cat, but no dogs, and the community wants to eliminate all pets, then in that case, a rule wouldn't work because although boards can enact rules, they can't contradict what is already in the association's governing documents. So in that case, we would recommend an amendment to their declaration because they need to fix what's already in their declaration in order to address it.
And there is a natural tendency, is there not, for boards to want to do this through rules because it's just easier.
Yes.
But in terms of future enforcement, are there benefits to putting it into the declaration instead of the rules?
Sure. If you have a rule that can be amended by the board, then this administration might implement a rule and the next administration may just undo it. Whereas if you want to have something that survives administrations and really shows the community's will, then in order to do that, you'd have a declaration amendment, which in the future would require unit owners to change it.
And the rules are subject to a test of reasonableness. And the only segment of our society that benefits from challenging what is and what is not reasonable happens to be lawyers, right?
Right. Right. That's definitely something that can be subjective, I think. And declaration provisions can be somewhat unreasonable as long as they don't contradict, public policy or things like that. So you have a little bit more leeway, I guess, in the declaration provision because the owners have to vote on it.
Before I turn to Howard to discuss some of the process, I want to ask one last follow-up to you, Lily. It's easy to assume, as you said, that the board typically has rulemaking authority, but there are some landmines in the governing documents.
Sure.
What are some of the ones that you've seen in the governing documents that might cause a board to think they have authority where they don't?
Well, a fun one to find is a provision early in the documents that allows the board to adopt reasonable rules regarding, say, anything, the use of common elements. And 7 provisions down, there'll be a provision requiring unit owner ratification of all rules. And it's not even in the same article. So it's easily missed if a board is just skimming through its documents. Sometimes there's limits on what the rules can regulate, only use of the common elements and not use of the units. So documents have a lot to do in the authority that the boards have.
Perfect. That's exactly what I was hoping to hear. Howard, now that we've got a template for where to go with the restriction, what is the process?
Good afternoon, everybody. Thank you for joining us. And Ken and Lil, nice to see you both. The process will generally be laid out in your governing documents as to, how the board should adopt rules and regulations, if that's what we're talking about. And you want to make sure that you follow that process properly. If you're talking about rules and regulations regarding unit use, the statute requires a 14-day notice of a board meeting that the board's going to have to adopt that rule. So you want to be very cognizant of that if you're adopting a rule that's going to affect unit use. While you may think that the board has the authority to adopt the rule, therefore we only need a 48-hour notice, you need a 14-day notice for that type of a rule.
Howard, is that 14-day notice posted, mailed, or both?
Yes. It is. It has to be delivered to the owners, and posted just like any other board meeting. I'm sorry, just like any other member meeting, even though it's a board meeting. You have to notify the owners, you have to post it. If you have 150 or more units and you have a website, it has to be posted on the website, all of those types of requirements. And then you want to make sure that the board goes through the formal process of adopting that rule. Motion, second, exactly what the rule is. Once the rule is passed, then you have an obligation to notify the owners of the new rule.
And how do you notify the owners of the new rule? Because there's a lot of people think that once we've adopted it, it's on the books, everybody is presumed to know.
Yeah, that's a good question. And I've seen a lot of associations get into trouble because of that. They pass a rule and then they don't do anything further with it. You need to look at your governing documents because some governing documents have specific requirements that say that you have to notify the owners 30 days in advance before the rule can go into effect. So for argument's sake, if the board adopts a rule officially on February 1st, and they never notify the owners of that new rule, there's an argument that they never notified the owner 30 days in advance of when that rule went into effect. So it's very important to make sure you notify the owners. And again, you would do that the same way that you would do any other official association notice. And hopefully maybe you have electronic notice. And if you do, and you have that consent, you can just blast it out to the owners that way.
So before we take the next step into the chronology and talk about responding to a violation, I think it's worth emphasizing to everyone that the drafting of a rule requires a little bit of restraint. Liliana referred to a pet rule, and you used the example, Lily, of adopting a rule where we're going to have no pets. And I think everybody who's listening to us already knows, based upon the Fair Housing Act, that there's no such thing as a no pets building. But I think there's another issue that I would ask everyone listening to consider, and I've had this conversation with a lot of my own clients, which is if you adopt a no pets or animals of any kind restriction, I want you to consider the burden you are taking on in terms of enforcement. Clearly, a dog is a pet. A cat is a pet. What about a goldfish bowl or an aquarium? And the real question I would ask all of you to consider when you draft a rule is, do you care about the goldfish or the canary or a 10-gallon aquarium? Because if you don't, then you shouldn't put yourself in a position where you have to undertake enforcement action against the goldfish in order to be able to keep out the dog. So when you draft, be sure to draft with a view toward what will we be willing to go to war over to enforce. Because if you're not, don't draft over broadly. The other point I want to make before we move on to the next step in the chronology is you heard references to what your declaration says or what your bylaws say. Be sure to check all of your documents, particularly those of you who have older documents. A lot of the older articles of incorporation from the 70s and early 80s require a vote of the owners to approve rules. So to the extent your declaration says the association can adopt rules to the extent provided in the articles and bylaws, and the articles say the members have to vote, but the bylaws have been amended at some point to say the board can do it, the articles control. So this process of identifying authority to adopt a rule is a bit more involved than you might think, and it's got to be followed, because a rule that's not properly enacted is not enforceable, and you don't want to find that out after you've already commenced enforcement action. Howard, Lily, any other comments with regard to the preliminary steps to create rules?
I just want to sort of piggyback on something that you said about how do they let people know about a new rule. I think it's important also to just periodically republish all of your rules to the owners. You get people changing units, they have new residents coming in. You know, people ought assume that when an owner purchases the property and they get that 3-inch stack of documents, that they're all running home to read them. And sadly, that's not always the case. And I think a lot of the violations could be avoided if people were better aware of the rules. So my recommendation is to just periodically, if you have email communication with your owners, republish all your rules. Let people know, once again, these are the rules that we're all abiding by, because I think a lot of people just don't know that, I don't know that the pool closes at a particular time, or that they're not supposed to leave their bikes out in the hallway. And some things that may make sense or seem to be common sense to some people are not common sense to others. And if people don't know about the violations that they are doing, they can't stop. And then you're in a cycle of enforcing and educating at the same time, which isn't really the most efficient way to get things done.
Okay, good point. Very good.
And to follow up on that,
You can
let me
never
just follow up on that, Ken.
Before you do, you can never be accused of giving too much notice.
Agree.
I'm sorry, Howard, go ahead, please.
That's okay. I was just going to say, if your association is large enough to have a website, obviously your rules should be posted on the website, and you can just put that information in monthly newsletters or whatever. Hey, make sure you check out the rules on our website. So that's another way to notify the owners on a regular basis.
Liliana, back to you. Now we have a violation. A client contacts you, says the following occurred. We believe it's a violation of our documents. You look at their rules or their declaration and you verify that based upon the facts shared with you, it is a violation. What is the first step involved, and what is the thinking involved in giving notice?
Well, I think the first step is, what kind of violation are we talking about, and whether this is a repeat offense. So back to the bike in the hallway issue that does happen frequently. I don't know that if an owner or a resident leaves a bike in the hallway, the first letter needs to come from the law firm. I think that we need to measure the weight of the notice by the type of violation that you're talking about, because unfortunately, if you go too heavy-handed in the beginning with something that is a product of possible miseducation or misunderstanding, you might get a reaction that then prompts the same reaction from the owner. So then we're now getting a letter back from the owner's legal, and back and forth, and things can escalate very quickly. So if we're talking about something that is maybe a first-time violation or a minor violation, sometimes a notice from the manager can be enough, pointing out the provision that's being violated and giving them time to comply. So we like to call that notice an opportunity to cure. You're in violation, you have 5 days to cure this violation. If the person does not cure the violation within that time, then I think it's time to start looking at escalating and either a response from or a follow-up from the law firm, or taking other enforcement measures.
Are there legal obligations, whether documentary or statutory, with regard to giving notice when there's a violation?
Absolutely. I mean, I should say there are differing requirements depending on what kinds of violations we're talking about. So your documents have just multitudes of requirements in there. Some of them have very specific language, particularly older documents. We see a lot of certified mail requirements in older documents. And while that's not something that's practical in today's day and age, sometimes you can have a requirement that all notices to unit owners regarding violations must be sent by certified mail. or they must be sent within a certain time frame. So the documents are certainly the first place to look to see. And like you just said, not just the declaration, the bylaws and the articles of incorporation can have provisions there requiring certain types and timeframes for notice. Statute could do the same thing. If you're giving notice about something that is a violation of the statute, there are certain statutory requirements to notice as well.
Well, and picking up on that point, Lily, if you're a condo or a co-op that operate under the arbitration guidelines of the state agency, are there specific legal requirements for notices that are a precursor to filing a petition for arbitration before the division?
Well, you need to point out the provision that's being violated. You need to give facts regarding the violation itself. Again, you need to give the time to cure, and letting them know that further legal action will follow if they don't comply.
There are 2 points you made there that warrant emphasis. Number one, the facts. If you want to impose certain remedies, for example, you want to levy fines, you can't later levy fines for violations that you didn't include in your description of the facts. So you need to be thorough there. Number two, you need to tie the conduct complained of to a specific applicable provision of your documents. I get a lot of complaints from clients about behavior they find objectionable that is not addressed anywhere in their documents. And thirdly, one of the common mistakes I see, and you mentioned it, but it bears emphasis, is give a specific deadline for compliance. Otherwise, your letter is simply a preliminary letter because there's going to have to be a second one.
Yep.
So
let me add one thing to that, Ken.
Please go ahead.
In regard to the arbitration notice, you cannot send a notice that will count as a pre-arbitration notice that requires immediate compliance. The arbitration statutes will not allow an association to demand immediate compliance and have that count as a pre-arbitration letter. You have to give a reasonable amount of time, whether that's 5 days, 7 days, whatever the case may be. And a lot of times we get complaints from the association of some bad actions, whether it's abusing the employees, abusing other people, excessive smoking, whatever. And they want us to send a letter that requires immediate compliance. And, we have to explain to them that you got to give them a little bit of time to comply. So that's just something you want to be aware of.
And it's, go ahead, Lily, please.
Well, I just wanted to add something that I don't think we've given enough attention to, but I know that we all agree on. The purpose of these letters, yes, we're talking about enforcement mechanisms today, but really the purpose of the notice of violation and the purpose of all of this process is so that people abide by the rules that they agreed to abide by when they moved in. So we're looking for compliance here. And if we give unreasonable requirements, like Howard was just saying, immediate rectification, or we're going to file arbitration, that's not really geared toward getting people to comply. I think, of course, it depends on the type of violation, and not every violation, is something that is accidental. Sometimes people know very well that they're violating the rules, but I think that there's a measure of information and really trying to just get people to comply. And our purpose here, part of it is to just get compliance first. And if we can't, then we go to the next steps.
One additional comment on this before we move into actual remedies, and that is, I had an incident just with a client this morning. A guy was menacing the elderly single women in the community. I have a simple approach. If someone behaves like a criminal, treat them like a criminal. If someone behaves in a way that warrants a call to the police, for God's sake, call the police. Number one, it's the right thing to do to protect yourself. Number two, if you are going to later claim that someone made you feel fearful for your life, and I'm defending the owner and I'm going to say, well, I noticed there's no police report here. You didn't feel fearful enough to call the police.
Yep.
It undermines the credibility of your position. If someone behaves like a criminal, treat them like one. Now, dealing with the violations themselves, Howard, one of the remedies that is available to associations, homeowners, condos, and co-ops is the right to levy fines or levy suspensions. Have you seen that used in a way that actually effectuates a deterrent or cures a violation?
It really depends on the association and the makeup of the people in that association. some owners are very much affected by a suspension of the right to use the common areas. For example, if you live in an association where you have fob access and you can control somebody's access to the gym or the library or whatever, and you can turn off that access. Well, if somebody is a gym user and you're taking away their gym access, that type of a suspension can be very effective in curtailing improper activity. On the other hand, if you live in an association that doesn't have the ability to, control that access, suspending an owner's right to use the common areas is really ineffective because have no way to enforce that. I've had association board members say, "Well, we'll stand at the pool and we won't let the people in." And I'm like, no. You can't do that, and you don't want to do that. So that's in regard to suspensions. Fines, it's a little bit different in my personal opinion. I have rarely found fines to be a deterrent in condominium associations because really, you can't leave for the fine. You put them on the account. And hopefully, if the owner ever goes to sell or if they go to refinance, those fines will be paid. So that's my opinion in regard to fines. Depends on the community, but not so much. Homeowner associations maybe a little bit more so because you can impose higher fines depending on the governing documents, and there's a little bit more flexibility in how to collect those fines. So again, depending on the community, I think suspension could be effective. Fines, in my opinion, not as much.
Well, in terms of distinguishing between which remedy would be most useful, discuss, for example, the difference between a guy who periodically parks in someone else's parking space as opposed to someone who makes an unapproved alteration on the exterior of the building.
Okay, well, those are obviously two drastically different types of violations.
And I suspect you're going to recommend drastically different remedies.
I guess we'll see. So the person who parks in somebody else's parking space, occasionally, maybe by mistake, maybe not so much by mistake, hopefully a letter, maybe, suspension of use rights, if you have that ability, might be able to effectuate change in that case, as opposed to a fine. If somebody makes a material alteration or changes the exterior of the building, again, to me, that's, you're talking, and I'm just using these terms without really meaning anything, a grade A offense to a grade C offense. Making a material alteration to the exterior of the building, to me, is a lot more serious of an offense, unless you're the person whose parking space is getting parked in. But
also, Howard, if the fine in a condo or co-op is capped, and it could be in an HOA as well if their documents don't provide otherwise, if the fine is capped at a certain level, what is the deterrent to force the owner to remove the unapproved alteration?
Well, that's when you got to go to the next step and you get into enforcement actions, whether it's a demand for pre-suit mediation in a homeowner association or the filing of a petition for arbitration, generally in a condominium or a co-op.
And I would add, just to sort of offer a different perspective on the parking. Look, if I don't pay the meter when I park out in public, I get a ticket. I got to pay a fine. If somebody is parking intermittently in somebody else's spot and they get the message it's going to cost them $100 every time they do it, that might be a useful deterrent. It's certainly more useful than telling them they can't go to the pool that has no fence around it anyway. So there are lots of options, and as you can tell, how to approach violations requires a bit of a discussion instead of a knee-jerk reaction. So, speaking of fines and suspensions, Liliana, can you walk everyone through that process? Doesn't have to be in the documents. I still get these questions. We don't have any authority in our documents to levy fines or levy suspensions. Where does the authority come from, and what is the process for implementation?
All right. So that's a long answer. I'll try to keep it as brief as possible given our time constraints here. But the statutes have helped us quite a bit in this regard. They now provide specifically for fining authority. Most associations can take advantage of the statute, and we'll leave it at most for now. But there are requirements that the statute imposes in order to levy the same process for fines and suspensions for violations of documents. The first, and I think the biggest hurdle for most communities, is they need a committee. grievance committee, a fining committee, you can call it any number of things, but there needs to be a committee of non-board members, at least 3 of them, and they can't be people that reside with the board either. This committee is going to come up later in my explanation, because the first thing that we start with is, as we've been discussing, the notice of violation, letting people know that they are in violation, and if the type of violation is one that you cannot give an opportunity to cure, or it's just something that is a repeat offense already, and the finding process is ready to begin, in that case, then the board needs to take the first action, which is to put on the agenda the issue of the violation and the fine, and vote on it. And if at that meeting of the board, a majority of the board votes to levy a fine or a suspension, then it is sent out to the unit owner or the resident, whoever it is that's being fined, with a notice saying the board has decided this, and there will be a hearing before this committee that I had referred to previously, where the fine and suspension is going to be considered by the committee, and they'll be allowed to either confirm or reject the fine. And that notice has to go out 2 weeks or 14 days prior to the date of the hearing. At that hearing, the resident owner finee, let's say, gets the opportunity to tell his side of the story or her side of the story or their side of the story, and the association does the same. The committee weighs it, and they determine whether they're going to accept or reject the fine or the suspension that was determined by the board.
Okay. That was a succinct description of an involved process, but
I tried.
it is important for everyone listening to understand that under the current incarnation of the statute, the process starts with the board.
Yep.
And what used to be a grievance committee that could be appealed to the board back in prior years is now a grievance committee that sits in an appellate capacity and has the authority to approve or reject what the board does, not modify it, but approve or reject it. Just to throw in a couple questions for context here. We just talked about what sort of violation would warrant a fine, what would warrant a lawsuit. One of the questions, not surprisingly, is how do you enforce the face covering requirement that many people still have in effect? You know, part of me would say levying a $100 fine every time you violate it would be a deterrent. But since it's also a life safety issue, I'm not sure that a fine is a sufficient response. Howard, I'll start with you. Do you have a comment?
Yeah, it's a little, obviously it's a little complicated, and it might be, you know, a little long. I'll try to keep it short. But I think it boils down to, we're talking about rules and regulations. I think if the board wants to enforce a face mask requirement, I don't think the board is, or the association is there to enforce county or other governmental regulations. The board is there to enforce association rules and regulations. So hopefully by now, you know, the boards have passed properly rules and regulations regarding this COVID that we're going through, requiring requiring owners to wear masks in common areas and that sort of thing. And once that is a properly passed rule and regulation, okay, then I think the board can enforce it, so that if you have a mask requirement that the owners are required to wear a mask in the common areas, and you have an owner that is not doing that, I think the board can enforce that. How does the board enforce that? I agree with you, Ken. This whole finding process, you know, that whole thing, we're talking weeks, you know, 3 weeks, 4 weeks, when your reality about meeting notices and that sort of thing is completely ineffective.
And by the way, pardon the interruption, Howard, you've already pointed out that you can't demand immediate compliance.
Exactly. So, you know, I think the way to do it, and there's a process that we thought, and we've actually instituted a couple times, is you have to send the demand for compliance. You have to give a couple of days. Then you can, what they call, you file a petition for arbitration with the request for the arbitration division to release jurisdiction to the circuit court, for the circuit court to issue an immediate injunction due to the health, safety, and welfare concerns. And that is a process that I've actually done a couple of times, and the division has been fairly quick to release jurisdiction to the circuit court, and then you go and file with the circuit court for injunctive relief.
The point I want to emphasize here, folks, is with your rules, particularly a life safety rule, doing nothing is not an option. You need to do something that lets the community know you're serious about the restriction, because if you do nothing, you send the exact opposite message. And there was one other question that warrants a comment, and Liliana, I'll toss this one to you. Can you impose a fine for the first violation? Because you addressed how to deal with inadvertence or first-time offenders. Can you enforce a fine for the first violation? For example, the mask violation. Can you enforce a fine the very first time?
Sure, absolutely. There's no, well, let me clarify this. There are a couple things that could stand in the way. Under the statutes, there's nothing that would require it to be a repeat violation in order for you to fine. Now, if your documents, either your recorded governing documents or your adopted policy for fining, require a particular number of violations in order to levy a fine, or require some other kind of notice or preliminaries before you can levy the fine, that's a different story. But under just a plain circumstance where their documents don't really speak to it, there's no reason you couldn't fine for an initial violation.
And there are some communities out there that actually have provisions either in their bylaws, their declaration, or in many cases in their rules, where they set fining levels at amounts below what the statute would authorize. And if you've done that, you've limited your ability to impose a fine. So if you say $25 for the first violation, guess what? That's what you can fine for.
Yep.
You can't fine in excess of the statute, but you can limit yourself to fining less. I don't know why you would, because if a fine is intended to be a deterrent, the higher the fine, the greater the deterrent. But be sure that you don't have old documents that were adopted 15, 20, 25 years ago that set a fining schedule that is below what the statute calls for, because that's what you're stuck with until you change it.
And I got something I'd like to add in regard to rules and enforcement. And it's very, very important from an enforcement mechanism. If you have a violation by a tenant or an occupant, you need to make sure the owner is notified as well. Anytime there's an enforcement letter or anything like that, the owner has to be notified, for obvious reasons.
In addition to the tenant,
in addition to the tenant or the occupant, the owner of the unit, if they are not the violator, and this goes for guests too, the owner of the unit always has to be notified, because ultimately it's the owner of the unit that's responsible. And if we have to go with further action down the road, whether it's a petition for arbitration or a lawsuit, hopefully not. But if you eventually get to those actions, it's the owner that's going to be named in those actions in addition to the violator. And if the owner hasn't been notified, you're going to have a problem.
Okay.
That's a really good point.
Okay, I appreciate that, because that is an important part of giving proper notice. So we've talked about fines and suspensions, and Liliana, you laid out the process, and we've talked about when a fine is appropriate or a suspension is appropriate, and when a lawsuit is appropriate. So let's talk about a lawsuit for a moment. First of all, most of the formal actions that we see filed to enforce the documents are actions for injunctive relief, but there are actually two types of lawsuits, one for damages, one for injunctive relief. Can you explain a little bit of the difference between the two and what kind of scenarios might implicate an action for damages as opposed to an action for injunctive relief?
Okay. Damages, for people that might not be up on their legalese, is money. So if you are suing for damages, you are trying to recover money in the lawsuit as opposed to require compliance or a particular action. An injunction is the kind of relief that you would seek if you're asking the court to make somebody do something or stop them from doing something. So really, that's the difference between the two. What kinds of actions would prompt an association to seek damages? Let's say that you have a provision that requires, only one boat be docked in a boat slip, okay? And somebody tries to cram in that second boat, okay? And in doing so, they damage the boat dock. And now the association is faced with not only the violation, which in itself might merit a fine or a suspension or whatnot because they broke the rules by getting both boats in, but now they've got a damaged dock that they have to repair as a common expense. Well, that's cost to the association that the association should be able to recover for. So in that kind of a case, if the association cannot get the money voluntarily from the owner, they file a lawsuit seeking damages for the money it cost them to repair the boat slip.
A more even more typical example is if an owner fails to properly maintain his or her unit, and the association is required and assume authorized to go in and
Assume
clean it up.
authorized.
For example, you have a hoarder, or you have someone who has a leaking water heater or a leaking toilet, and the owner is just gone and won't respond to communications, and we go in and fix it because the statute gives you a right of access to prevent damage. That too would give rise to a damage claim, correct?
It would, but it opens up Pandora's box when you're talking about self-enforcement and whether the documents allow it, what kind of liabilities the association might be exposing itself and taking these kinds of self-enforcement actions. So yes, that's another way that it can come up. It's just a little bit more complicated sometimes.
It is, but this is an area that a lot of you listening deal with regularly. And, you know, as a linear thinker, as I am, I have always taken the position that if there's a way to cure the problem, to stop a leak, fix the problem, chase the money. Because if you have an ongoing problem where water is leaking, you have an ongoing problem where bugs are coming in or rats are coming in or something is creating a risk that threatens to expand and affect neighboring units and common elements, it stands to reason that you can't say, well, we're not doing a thing. We're going to make Howard, it's his unit. We're going to make him do it. The problem is nothing's getting better. In certain circumstances, you have to recognize that an owner who is not willing to be cooperative should not stop you from fixing a problem that threatens that unit and neighboring properties. Fix the problem, chase the money. You have an action for damages, as Lily pointed out. Suing for injunctive relief, and you talked about, Howard, you talked about the efficacy of fines sometimes with face coverings. If you have an ongoing problem with a hoarder or a unit that has fallen into really disgusting condition, and you live next door to it, do you want the association to spend the next year and a half suing for an injunction to make the owner clean it up, which the owner might not do anyway? So these are things to consider. And it's also worth mentioning that if your documents give you a right of self-help, as you alluded to, Liliana, if you have the right of self-help, the court might not give you an injunction.
Yes.
The court might say you have an adequate remedy at law, which is that you can go in and fix it and then sue for the money. So these are all things that need to be taken into consideration. And Howard, I would ask you to offer a comment on two issues. Number one, when we don't have a restriction that addresses the behavior, it's easy to just say, well, it's a nuisance. Can we sue under the nuisance clause? What is your comment on that?
Yeah, my answer is yes, you can sue under the nuisance clause. But if there are 100 different association documents, there are 100 different nuisance clauses. Some nuisance clauses prohibit nuisances in the common areas only. Some nuisance clauses apply only to other owners and not if somebody is harassing staff or something like that. So, you know, you're right, Ken, the nuisance clause is attempted to be used as a catch-all, and in many cases it can be used as a catch-all. But the association really needs to take a close look at its nuisance clause and what it allows and does not allow. And for example, if there's a nuisance, there's nothing else addressed in the governing documents. Just as an example, loud noise. Okay, if there's nothing in the documents governing loud noises or music coming from a unit, and there's a nuisance clause that allows the association, prohibits nuisances in the common areas. Well, there's a question, can you enforce that against a nuisance coming from the unit? So you do need to take a close look at that. But in many cases, you can use a nuisance clause as a catch-all, but you just have to be careful.
Well, and I would point out to everyone listening that one of the goals of drafting and one of the benefits or advantages if you're in an enforcement posture is to have a violation that can be determined from an objective perspective, as opposed to a subjective perspective. So for example, if you're an HOA listening and you have architectural control guidelines and you have architectural control guidelines that are based upon aesthetics, that is purely subjective. Establishing a nuisance is purely subjective. I've used the example, with pets and use the use of the term reasonableness, that if you have two people in your building that get attacked by a dog, And one of them goes in front of a judge who went out for a jog last weekend and got bit on the behind by a dog. And the other one goes in front of a judge who works part-time for the Humane Society. You might get two very different perspectives on what is reasonable. So when it comes in, when you have an opportunity to enforce, draft specifically, and if you draft something to prohibit the behavior, you'll never have to prove that it's a nuisance, because under Florida case law, you don't have to prove it. It's presumed to be a nuisance if it's a violation of a specific provision of your documents. And speaking of subjective issues, Lily, I want to bounce back to you. Howard referred to noise. You get a complaint from the downstairs owner that I hear them walking around, I hear them bouncing a basketball. Every time they roll a chair away from the kitchen table, I hear it, it's making me crazy. What do you, or they have their TV on too loud. What do you do?
Oh my God, this is the bane of my existence, because this is condominium living 101. It's unfortunately part of living in a building that you share all the surrounding walls and floors and ceilings with other people, and you're always going to have some measure of noise. So your question is exactly the kind of question we get all of the time.
Absolutely.
It's really difficult. One of the easiest things to check is if you have an upstairs neighbor that recently changed floors, do your documents have soundproofing requirements for tiles or hard floors? Do they have carpeting requirements? I mean, that's kind of the easiest thing that you can do. Beyond that, it becomes sort of a measure of, like you say, reasonableness. One of the things that I recommend is have the unit owner contact security or contact a manager when this is happening, so that there's more than one person listening to this, because since it is so subjective, some people are very, very sensitive to noise, and some people, it doesn't bother them, and they understand it as normal living, and sometimes you can hear it. We've had owners send in audio recordings that they believe to be just, hurricanes and tornadoes happening right above their heads, and in reality, you listen to it, and it's just normal living. And it is, you have to be sensitive, right? Because they are being annoyed, but by the same token, you can't have people upstairs not live. So it's a really difficult thing. We've had people call in sound acoustic experts to come in and measure the sound. There's a lot of things that the association can do, but I do think that it should at least take some measures to try to substantiate or not what the concern is, because from the unit owner's perspective, it may be really bothersome to them. And if the association does no investigation whatsoever and either enforces or ignores, I think you're going to have a problem on either end of the spectrum.
I think that last point you just made is the absolute key, Liliana, which is that once you are put on notice that an owner is alleging that a violation exists, you need to do something. You need to investigate it. For example, are there any other owners complaining?
Right.
And you go to the unit when the owner claims that noise is occurring and have the manager or a staff member or a couple board members hear it.
Right.
Can you determine that it is a level of noise, as you very appropriately point out, that is something you should normally expect in a multifamily building? Or, I had one where the owner worked in a bar, came home at 2 in the morning, and that's when he did his weightlifting. So, there are noises that are unreasonable, we can all agree. But there may be many circumstances like this, where the board has the prerogative, do they not, to determine that this is a dispute between two owners, and we're not going to take one owner's word over the other.
Yes, I think that if the board has done its investigation and has determined that it is not something that would rise to the level of a violation of their documents, I think at a certain point, the board does have the prerogative to say, we've done what we can. What we have found is normal living noises, or it's not something that anyone else in the building has complained of or anything like that. Unit owners and residents still have the right within the documents to enforce documents against each other. And that's something that I think is lost on a lot of unit owners and residents. I think they assume the association has to make every step, every enforcement effort, and that's just not the case. I mean, these are restrictions that can be enforced one against the other.
They also assume that the association has to take up their individual cause, even if no one else is complaining, and even if it's entirely subjective.
Yes.
That's not the law.
No.
So, Howard, give me give me the short version of this one because we're running short on time and I have a few other more involved topics I want to cover, but it would not be good for us to ignore one of the most obvious and significant issues that arises when enforcement occurs, and that's costs and legal fees. How do you factor that into your advice when a client comes to you with a violation and says, I want to sue him, I want to sue them, I want to sue everybody?
That's a great question, Ken, and obviously it's a very serious concern, especially over the last year with some of the financial issues a lot of the associations are facing with people being out of work, and there might be some assessment collection issues and that sort of thing. When the client comes to you and they say, okay, we've had enough, we want you to file a petition for arbitration, or we want you to file a lawsuit, whatever the case may be, I think it's the attorney's obligation to tell the client what the expected costs are, which you can never tell for sure, but you can certainly get a range or certainly a minimum, what the expected costs are and what the expected time frame is. In an arbitration proceeding, you might be talking about a couple of months or 3 months, depending on how involved it gets to come to a resolution from the arbitrator. And in a litigation proceeding, you could be talking a year to 2 years or longer to get a resolution in a litigation proceeding with the associated legal costs. So I think it's very important to advise the client of those options so the client is making an informed decision when they decide how they want to proceed.
When do legal fees become recoverable?
Legal fees are generally recoverable. Well, let me start over. It depends. Okay. If you're suing under the association governing documents, generally the governing documents have a prevailing party attorney's fees. Generally, the statutes have prevailing party attorney's fees. Okay, 718, 720, depending on what you're suing on. But not, if the association has been engaged in letters back and forth between an owner for a year, okay, for a year before they decide to file the petition for arbitration or file the lawsuit, can the association recover those legal fees for that year prior to actually commencing litigation? And, unless your governing documents give the association that specific authority, the general answer is no. That's the cost of doing business. For the association's attorney to send violation letters and enforcement letters is the cost of doing business for an association. And that's why you have a legal line item in your budget.
And I want to tie this into a comment that Liliana made earlier and that I commented on. We talked about drafting pet restrictions. If you say no pets or animals of any kind, I would ask all of you listening how you think your owners would react if they found out that you spent $20,000 on litigation to get rid of a goldfish. I'm going to let that hang there for a second because I want you to think about the impact it has on how you draft your rules. Don't set yourself up. We could put this on a bumper sticker. Don't set yourself up to spend $20,000 litigating over a fish tank that you don't care about.
I just want to jump in before we move off of this because it is such an important topic and one that, most associations are very sensitive to legal fees and they're worried about how much enforcement is going to cost, and they have to balance the fact that they're required to enforce their documents because that's what the association is supposed to do. They're supposed to enforce this with the cost. And as Howard says, it really does depend on how much it's going to cost. But one of the things that people need to understand as well when they're pushing for litigation, sometimes it's not just the fact that it might cost them so much to sue. The thing is, they might lose. And if they lose, the statute provides that the prevailing party gets the attorney's fees. That means you might not only be looking at whatever thousands of dollars you spent on the association's attorney, but you're also going to have to pay the unit owner or resident's attorney's fees as well. So it's not to dissuade people from litigation. Litigation is sometimes the only way that you can get relief, and it's necessary, but it's something to consider. To try all of the enforcement tools available to the association, not just focus on a singular option. So
let's talk about some of the circumstances under which the association could wind up not prevailing. Let me start with one of the more obvious ones. You referred earlier to, there's noise coming upstairs. Do you have guidelines for sound deadening? What if the floor was installed 7 years ago?
Right. Right. So one of the things that may come up is, of course, in a litigation, the association files its claim and then the owner has the opportunity to defend that claim. And one of the legal defenses that comes up all of the time is the statute of limitations. And that's that the law says you have X period of time to file a lawsuit after something happens. When we're talking about a declaration or association governing documents, these are all equivalent to breaches of contract. And so you're talking about 5 years. So if it is 7 years after the fact and nobody has done anything, you might be looking at a statute of limitations defense that cannot be overcome, even if you have the best case in the world, because procedurally you're stopped from bringing that case.
Now, we could spend the next 20 minutes talking about this, and I know you don't want
Yeah.
to. Neither do
I do. I like talking about that.
But 5 years from when?
Well, I was just going to go there. I mean, the breach has to be something that is discoverable, right? Because if the owner in the dead of night replaced his floors and the association had no way of finding out about that and had no complaints for those 5 years and no reason to suspect that there was a problem, then at that point, there's an argument back from the association to say it wasn't discoverable. We didn't know there was a breach, and there was no way for us to know that he didn't install the soundproofing.
So I'd ask Howard to be devil's advocate, but he would enjoy it too much. So let me be devil's advocate. So if I'm the owner's lawyer, I'm going to say, how could you not know we installed a tile floor? They came through the front desk. We gave the office the guy's license and permit, and you heard the noise from us putting in a tile floor. How can you say you didn't know?
Well, that wasn't my hypothetical. My hypothetical was in the dead of night and no complaints for 5 years. I made my question easy.
Nobody replaces their tile floor in the dead of night. I mean, I had.
Oh, yes, they do.
I had one where a lady had a cat for like 10 years and she snuck it in and out in a shopping cart covered with like rags and towels. So let's shift to a different approach. That's statute of limitations. What if the owner says, well, my floor is there for 4 years, but I went to a board meeting, I gave my documentation to the president afterwards, and he said, fine, do it.
Right. So you have a waiver because you have a knowing relinquishment of a known right. The association knew that you had to put in the soundproofing. You told them I didn't put in the soundproofing, and then they told you I didn't put in the soundproofing, and they said, okay, that's fine. So now the association has given up its right to basically go after you. Estoppel is another way that
I'm going to go into that next. I'm going to go into that next, but I want to follow up on the waiver. What if in that scenario, the president said, yes, install the floor, but all other floors had been approved at a properly noticed open board meeting?
I'm sorry, go ahead. Repeat that.
In the example I gave you, the president said yes to the hard surface floor, but all other flooring installations had been approved only at open noticed board meetings by the board.
Well, I suppose the argument there would be that the owner should know that this wasn't the proper approval process, but I don't know, that gets a little complicated. I defer to the litigator. Howard?
Well, part of the reason I'm throwing this out is because I want everybody to know how complicated it is, because if the declaration says this requires approval from the board, Howard?
Well, there's case law on that point. Now, if the president had approved a half a dozen of these and everybody knew about it and didn't do anything about it, that's one story. Then I agree with Liliana, there's waiver. But if the president just approved this on his own without the rest of the board knowing about it,
right?
There's case law that says, the owner has a responsibility here too, and the documents require board approval, and the owner knew he or she had to get board approval when they didn't. So, like most things, when it comes to litigation, there's no easy answer, right. But there's pros and cons on both sides.
And for those of you listening that have an informal approach to things, because your community just typically doesn't have much tumult, it only takes one incident like this where your informality can bite you someplace you don't want to be bitten. On items that require approval from the board, it is good to have clear guidelines for when board approval is required. If we're talking about, say, window replacement, to have a set of specs for the kinds of windows that you will approve, so that it's clear to the owners, clear to the contractors, and clear to the current and future board members. The more that you can codify the process, the less subjectivity there is in the decision-making, and the less subjectivity there is, the easier it is to be consistent and uniform. And speaking of being consistent and uniform, Howard, what is selective enforcement?
What is selective enforcement? That's probably the bane of many associations' existence. Selective enforcement is when you're in a no pet building and there are 10 dogs in the building that everybody knows about. And then Mrs. Smith brings in a dog and the board doesn't like Mrs. Smith because she's a pain in the you-know-what at unit owner meetings. So now that Mrs. Smith has a dog, the board says, send her a violation letter. We want to get rid of that dog, okay? And Mrs. Smith turns around and says, wait a second, there's 10 other dogs in the community. You can't do that. And Mrs. Smith is right. That's selective enforcement.
Now, you
have to
said 10
enforce
dogs.
your governing documents uniformly.
You said 10 dogs. What if there's only one?
I think there's an argument for selective enforcement. Again, it depends. If the board knew about it, if that other dog walked through the lobby 3 times a week and everybody knew it was there and the board did nothing about it, and now they want to enforce against the other one, I think there's a case for a selective enforcement. But if the board wasn't aware of the other dog, like you say, they bring them out in the shopping cart covered in, whatever, the board has to be aware of the other violations for there to be selective enforcement.
And typically, selective enforcement requires a pattern of non-enforcement. But the reality is in your communities, folks, that people are legally entitled to rely on 2 things. Number one, what's in the documents, which unfortunately nobody reads. And number 2, what you allow them to see. And everybody sees. Sometimes they see what they want to see. So if your documents say no pets, but you allow them to see lots of pets walking around, it's hard for you to later say that you didn't have the right to rely on what we allowed you to see. That is the essence of selective enforcement, which is that it is grounded in the concept of estoppel. And estoppel is you make a representation to me, I rely upon it to my detriment, you can't change the rules on me. So what is, Howard, before we go to the last topic I want Lily to address, what is grandfathering? We've talked about adopting a new rule. What does grandfathering mean? Does that mean if I got here before the rule was adopted, I can live under the old rules?
I think that's what it means when Ken looks in the mirror. He sees a grandfather. But putting that aside,
Yeah, you're older than me.
Wow.
What grandfathering means is if there's a new rule being imposed or something like that, under certain circumstances, people have a right to keep what they had done under the previous rules. It's just like you said, Ken, for example, this is a building that allows pets, has always allowed pets. And now the board and the membership want to amend the declaration so that there are no pets. Well, they can make that amendment. They can amend the declaration so there's no pets. But all existing pets at the time that amendment is made would be grandfathered in. And typically that information would be in the documents that the existing pets are grandfathered in, but they can't be replaced. So it's a mechanism where there's going to be a significant change in the community for whatever reason that allows people who had abided by the previous version of that change to keep what they've done until that, for a certain period of time. Now, there's certain things grandfathering wouldn't apply to. For example, if for whatever reason people have been parking on the grass and there's nothing in the documents that say you can't park on the grass, and then there's an amendment made to say no parking on the grass, well, just because you parked on the grass last week doesn't mean you're grandfathered in. So something like that would be effective, for everybody moving forward.
And grandfathering in typically, in concept, it could exist on 3 levels. 1, a unit is grandfathered in, which never occurs. Number 2, an owner is grandfathered in, which would be applicable in a condominium where you adopt leasing restrictions and an owner doesn't vote for them. That owner would be grandfathered in. And then there is what Howard is describing, which is the existing violation before the new restriction goes into effect is grandfathered in. So we can't make you get rid of, for example, if we say you can't park a pickup truck beyond the half-ton capacity on the property, and you've got one before the rule is adopted, you can keep that truck, but when it comes time to buy a new vehicle, you need a vehicle that complies with the rules in effect at the time. Liliana, my last question, and then we'll do closing thoughts. For clients that have an uneven history or a history of lax enforcement, How can they resurrect a restriction for prospective enforcement? Can they? Because I've just said people rely on what they see. How can we breathe life back into restrictions that haven't been enforced?
So there's a concept that we like to call chattel shipping, do a chattel shipping resolution. And basically it's where there is a provision in the document that hasn't been enforced in the past, that maybe a new administration comes in and says, why aren't we enforcing this? This is what we want. We don't need to amend our documents. We just need to enforce what we actually have. And what you can do is, as a board, you can draw a proverbial line in the sand and say, from this point forward, we will be enforcing this provision that already exists. We haven't done so in the past, but going forward, we intend to do that. And they do so at an open board meeting. They notify the owners and the residents that this is the intention. And going forward, they've at least made a demarcation line between what wasn't happening in the past and what will happen in the future, giving the people the notice that is required, and somewhat trying to cure past failures to enforce, trying to get over the waiver arguments or the estoppel arguments that might come up. Not always successful, by the way, because unfortunately the judicial system doesn't always see it quite as clearly as we see it, but it is a mechanism that we try to use to make things clear. It's the option that you have.
The bottom line is that the restriction that hasn't been consistently enforced is not necessarily gone forever.
Right.
But the extent to which you've allowed violations may make it, let's face it, Howard said 10 dogs. If you have 10 units with pets in a 20-unit community, I'd say your pet restriction may just be gone. I mean, but if it's 10 units in a 1,000-unit community, you can get back to some level of enforcement. And with that, Howard, any final thoughts?
Yeah, first I want to thank everybody for joining us today. And Ken, thanks for moderating. Lily, thank you. One thing that's very important is when you're enforcing your governing documents, unless you have an owner's consent to receive electronic notice, official associations electronically, all violations need to be documented in writing. Emails to the owners, talking to them in the hallway, talking to them at the pool deck mean nothing when it comes to us to follow up on the enforcement. When somebody calls us or comes up to the attorney and says, we sent this guy 20 notices about the violation, we want you to send them a letter and we want you to do this. Fine, show me what you sent them. And they've sent nothing, emails or a notice pasted on their door. So when you're enforcing governing documents and violations, do it in writing. I think that's the best advice I can give everybody.
Absolutely. Liliana?
Words matter. What your documents say, that matters. What your documents limit you to, that matters. And what it requires you to do, that matters. So I think that the best thing that association boards can do is familiarize themselves with their documents and then measure their expectations accordingly. Because we can help you enforce your documents, but we're not magicians. And if your documents don't let you do a particular thing, or they have requirements before we're allowed to step in, or you're allowed to take enforcement measures, we can't just erase those from happening. So I think it really matters what your documents say and what the law says, and don't skip steps, because it's being penny wise and pound foolish. If you just want to rush to the final enforcement action and you haven't taken all the preliminary steps, you might end up spending a lot of money and not getting the result you want, which ultimately is compliance. That and republish your rules. I think that's really important. I think people really need to know what their governing documents and their rules say, remind people regularly, and I think it's going to help.
All right. Well, first of all, thank you, Howard and Lily, for a lively discussion. My parting comment is, and it will be redundant, make your guidelines objective everywhere you can. Look at your documents. Enforcement is often looked at the end, the fine, the suspension, the lawsuit. But enforcement is set up without exception by what you do at the beginning.
Yep.
Be clear as to what you want to restrict and address it. Don't overreach, don't write overly broadly. For God's sakes, don't try to use Latin or fancy legal language. Plain English is best. And take things into detail in your rules, not necessarily in your declaration, so that so it's easier to be consistent and uniform. And be consistent and be uniform. And if you have restrictions that you don't enforce, the best thing you can do is remove them. So with that, we had over 800 people here at various points. I want to thank everyone for attending. Again, I want to thank Howard and Liliana for a lively and hopefully educational discussion. Everyone stay safe, stay well, and we will see you all again soon. Thank you very much.
Thank you so much. Have a
Thanks,
great day.
everybody.
Thank you.
Bye.